Thank you, my Lord. I have completed my submissions. Thank you.
Could I just raise one matter with you?
I haven't completed.
Lord Pennick, before you sit down. It occurred to me that, as you'll know, there is a Council of Europe European agreement which governs the rights of parties or indeed other persons participating in proceedings before the Strasbourg Court in relation to matters such as correspondence, attending the court, and
Yes,
so forth.
yes.
And in relation to correspondence, the contracting parties, that's to say the UK amongst others, shall respect the right of the persons referred to, that's parties to the proceedings, to correspond freely with the court. And then it goes on to say there should be no interference except, and then we have the usual requirements in accordance with law necessary in democratic society, in the interest of national security, etc. And it occurred to me, while that's not Article 34, it indicates that it's not an unqualified right in relation to correspondence with the court. And I wondered if one might say the same about Article 6 itself in relation to domestic proceedings not being an unqualified right. And that might lead one to, it may not be for us appropriate for us to express a view on the point, but it might lead one to question whether Article 34 is necessarily to be construed as being different from Article 6 and from this treaty in conferring an absolute right.
Well, my answer to that in relation to domestic courts is, of course, I accept there's no unqualified right of access to a court. I gave examples of limitation periods, matters of that sort, but all the authorities indicate that what cannot be interfered with is the essence of the right. That cannot be the subject of a restriction. And my submission is that Article 34 must entitle the applicant to put his case as he sees it before the court without restriction, so that the court can itself assess its strength or otherwise. And we had this discussion this morning. I submitted that in a domestic context, one party cannot restrict the ability of the other party to put his case before the court, so that the court decides. The treaty to which the Lordship refers cannot undermine Article 34 in relation to the contents of the application, and I've relied on the authority of the Grand Chamber Authority, which I submit is in very clear terms, and unsurprisingly so, because any other approach will mean that a respondent state may limit the ability of the complainant to put his case before the court so that the court can pronounce judgment, can assess its merits or otherwise.
There are cases, are there not, in which a total prohibition on certain litigants or classes of litigants has been upheld as not impairing the essence of the right.
Vexatious litigants.
Also mental patients, and the case law on people suffering personal injury in military service, where the pension rights were compulsorily substituted for a right of action, upheld.
Well, yes, certainly in relation to mental patients and in relation, there are statutory restrictions your Lordship is referring to in those contexts, but in order to be compatible with the convention, there must be an ability. There's no restriction on the ability of the applicant to put his case before the court. If he makes an application to the court itself will decide, according to law, what the answer is, and the case will be dismissed. But what we are concerned with here, in my submission, is entirely unique, that there is a jurisdiction in the European Court. Everyone accepts on the international plane that it is for the European Court to determine the merits or otherwise of the applicant's complaint, and yet, uniquely, he is prohibited from communicating the substance as he sees it of his complaint with that court. And I say that is quite unique, it's quite remarkable as a restriction in relation to a court which does have jurisdiction. There is jurisdiction in these circumstances for the court to determine whether or not the trial was unfair in breach of Article 6, and yet a restriction on my client putting to that court what he regards as material to that complaint. I say that's unique and indeed is a breach of the essence of the right which is conferred by Article 34.
Assuming we were against you and the appeal were dismissed, what steps could then be taken in Strasbourg, if any?
If this court were to dismiss this appeal, then the Strasbourg court, on our application, could decide that it is a breach of Article 34 for the applicant to have been impeded in his ability to communicate with the Strasbourg court. The Strasbourg court could also decide that it is appropriate for it to request the United Kingdom to provide the sensitive information.
Could you request them to do that?
Oh, yes, we could ask the...
Without being in breach of the injunction? Yes, you could.
Well, no, it wouldn't be in breach of the injunction for us to ask the Strasbourg court to request the United Kingdom to provide the sensitive information, and it would then be a matter for the European Court to decide under Article 38 to make that request if the United Kingdom decided, and it's speculation whether the United Kingdom would comply or not, that it would not provide information, perhaps because of the contents of the closed schedule to the PII certificate, then the United Kingdom would be at risk of being found to be in breach of Article 38 of the Convention. So there are those...
Which is not something you could complain of on behalf of your client. It would have to be raised at the international level, wouldn't it, by the Committee of Ministers?
If there were a breach of Article 38,
yes.
If there were a breach of Article 38, then there would be no practical advantages for my client unless the Committee of Ministers decided to take action against the United Kingdom.
But you would pursue your original claim under Article 6?
Yes, and it may follow if the United Kingdom were to be asked to provide the information and were to decide to decline, that may well have an impact on the way in which the European Court decides the substantive issue of whether there is a breach of Article 6, because it may take the view it hasn't received an adequate response from the United Kingdom on a matter that concerns the European Court. So I don't shy away from the fact that there are those further steps that could be taken. Yes, indeed.
Thank you.
Before you sit down,
yes,
could you advise those behind you that the statement of facts which you so helpfully provided with, we've only got copies of one side of the paper?
Oh dear. Well, it's not those behind me, it's me, because...
Odd numbers only.
My clerk statement of facts. Copied it.
We've got pages 1, 3 and 6.
Well, I am terribly sorry. I think the only pages that may matter are the questions, but I will correct that, and I will this afternoon when I get back shout at someone and shout at myself, and I will make sure that members of the court receive the full version.
So the Sedley rule of documents applies.
It will indeed, my lord.
Live
Yes,
well.
No need to shout. No need to shout.
I won't shout, no, because I'm Oh yes. Well, I'm grateful. So I will do that. I apologise for that, but I'm reminded by Ms. Brimlow that in relation to the United Kingdom providing information to the Strasbourg Court if it is requested by the Strasbourg Court under Article 38, the terms of the order which Mr. Justice Ouseley has made on its terms would prevent the United Kingdom from voluntarily providing this information to Strasbourg. One would have to go back to Mr. Justice Ouseley or another judge in order to secure by agreement a variation of the order to enable the Attorney General and the United Kingdom to provide the information. That would be, that's Ms. Brimlow's understanding, and it's my understanding as well of the the effect of the order that has been made. The order, of course, is in the core volume Appendix Part 1, and it can be found on page 1, which is MS page number 78. And it's in absolute terms. It's not simply an order that affects us, but it's an order to the world. So that would have to be clarified. But if the United Kingdom does wish, if the United Kingdom is requested to provide the information and wishes positively to respond, then no doubt there can be a variation by agreement. Yeah, but that would follow. Nothing further. Thank you very much.
Thank you, Mr. Thank you, Lord Paddy. Mr.
Thank
Eady.
you.
My lords, my lady, our learned friend started with context, and I intend to do the same. And if it makes your blood run cold, to some extent, so much the better. My lords, my lady, the first point, by way of context and background, you know, this appellant was convicted of murder by a jury after a trial involving an in-camera process. That process was ordered by the trial judge after reaching two linked conclusions, or two separate conclusions perhaps. First, that a fair trial would continue to be possible. Indeed, as the Court of Appeal on the interlocutory appeal noted at paragraph 6, see MS 141 in the appendix, Mr. Justice Ouseley, for he was the trial judge, made it plain that he could never have made the order that he did if the consequence would, in his view, have been an unfair trial. So that was the first of the conclusions he reached. And the second of the conclusions that he reached was that unless those proceedings were held in camera, or part of them was held in camera, and you've seen how that expanded, but in the end it was the defence case plus the rebuttal, to come to a question I know you've been exploring this morning, unless that part of the proceedings was held in camera, there was a very real possibility that no trial could have taken place at all on the charge of murder. And if one goes into...
That was a method of ensuring that the jury heard all this material.
Exactly so. Exactly so. That was the only way in which it could be done. You have the judgment or the ruling pursuant to which that order was made in your appendix in the first bundle, the core volume with the appendix part 1 in it. If you go to MS 120 or internal page numbering 42, do you see that's a transcript? And that is the ruling of Mr. Justice Ouseley at the trial, pursuant to which he made the in-camera order. And if just to show you the relevant bits very, very quickly, you will see that the effect of the order is summarised at the bottom of MS 121 by the letter F. Precisely the point my Lord Clerk has just put, the press and the public will be excluded from parts of the trial. The jury, the defendant and his lawyers would hear the whole of the evidence, any cross-examination, the evidence of the defendant on his behalf insofar as it relates to matters heard in camera and so on. You'll see although he concluded that he was exercising an inherent jurisdiction in doing so, that inherent jurisdiction was to some extent regulated by Criminal Procedure Rule 1610, which you see at the top of page 122. And you'll see the twin bases on which such an order is envisaged in that rule. See by the letter B on page 122, national security or the protection of the identity of a witness. And the learned judge's approach, one sees if you flick on a few pages, you'll note the reference to inherent jurisdiction at the bottom of page 125 by the letter H and over to the top of the next page. But his essential approach one sees from page 131, still on the MS numbering. Note in particular the section, a little paragraph at the beginning of page 131, beginning on the second line between A and B, This is not a question of balancing the public interest in a fair trial and open justice against the problem of an unfair trial. No balance of that sort can possibly be struck if the trial in consequence of an in-camera ruling were to become unfair. The in-camera ruling should not be made, and the prosecution should be left to decide whether or not to proceed. But you'll see that subject to that rider, he deals between D and F on the facing page, page 132. He deals with the initial question, or the question assuming that the trial will not become unfair. First of all, he says, whether the Crown has made out a sufficiently strong case that part of the evidence must be heard in camera, but to protect the interests to which 1610 is directed. That is the first part of the question. This involves a scrutiny of the reasons provided in the material supporting the Crown's claim. I note that there is a ministerial certificate. So there was a PII certificate even at that stage explaining the concerns that arose. That's the first question. The second question is the one of fairness, logically the precondition as we've seen earlier, and you see that recorded at 133 by the letter B. It is perhaps to be noted, just going back to 132, that in relation to the objection to that trial, or that mode of trial, reliance was positively eschewed in relation to Article 6. Look at the top of page 132. Mr. Robertson was representing the defendant, as he was, and he didn't find any additional assistance in Article 6 for the reasons that is given, but perhaps for the more fundamental reason that fairness is a prerequisite to the determination of a criminal charge under Article 6, just as it is under the domestic rules governing the prosecution of criminal offences. But his concern, or a particular concern, I mentioned that was the only way in which the murder prosecution could perhaps be mounted. We see that reflected at 136 by the letter C. And his conclusion that nevertheless a fair trial could take place despite the in-camera order being made is at 137 by the letter E. You see just above the letter E, I'm quite satisfied. And if you're still in that bundle, if you go to the next page, or the next two pages on to MS 140, you will see the interlocutory appeal being disposed of by the then Lord Chief Justice, Lord Phillips, in a short ruling at MS 140 to 141. And the guts of that ruling, it might be thought, are in paragraphs 8 and 9 over on page 141. So they conclude that for the reasons that the learned judge gave, which I've just taken you through, an in-camera order was appropriate. And the upshot of all of that is that there was a trial for murder, where perhaps there might not otherwise have been one, and at the end of that trial, the defendant was convicted of murder, and Mr. Justice Ouseley made the order, the first of the orders that we're now arguing about. The terms of it are recorded in the Statement of Facts and Issues at paragraph 6, MS, page 27. So that was what happened up to the end of the criminal trial. There was then an appeal by the defendant to the Court of Criminal Appeal, this time a substantive appeal against conviction. He'd already had the interlocutory appeal you've just seen, and the Court of Appeal's ruling on his appeal against conviction starts at MS 142. The court headed, as Lord Pannick has already pointed out, by Lord Hughes, sitting with Mr. Justice Saunders and Mrs. Justice Thirlwall. And a variety of grounds are advanced. The relevant one for our purpose, and I'm not going to take you through it in any great detail, but the relevant one for our purpose is ground 2, you see the title on MS 147, just above paragraph 18. And you'll see that what is being argued is effectively exactly the same point, or exactly the same points, ex hoc. Paragraph 20, no attempt by the Court of Appeal to shut this appeal down on the basis that the point has already been run, because as they say there, well, we can look to see whether in fact the consequence of the in-camera order was an unfair trial. So that's what they then proceed to examine. And in particular, you will see, could I invite you, rather than reading it out, could I invite you just to cast an eye down at paragraphs 22 to the end of 24, and you will see the guts of the arguments that are being run. So you'll see there the various strands of argument that were being run, and the court rejects in 22 as the merest speculation, see the second sentence of 22, the principal way in which the unfairness case was put, namely that if the trial had happened in public, there would have been greater publicity, leading to additional witnesses coming forward to support the defendant. The witnesses, he asserted, would have confirmed the gangster characteristics of those he said gave him the deceased's checks, credit card and banking details, and you've seen the way the prosecution case worked. It was effectively from the dishonesty to an inference that he'd been involved in the murder. Plus, he said, witnesses testifying to his good character would have come forward, and that was rejected as the merest speculation in 22. They also rejected the further suggestion, as you see in 23, that further material on which cross-examination could have been mounted would have emerged on the basis that the kind of material that Mr. Robertson was able to suggest might have emerged was in fact already available and no attempt had been made to deploy it. And they rejected as similarly unarguable, their words, in para 24, the additional character evidence emerging. And their ultimate conclusion in relation to all of this is to reject the second ground of appeal, see para 28, as unarguable. And it is perhaps worth just flagging up and noting, because it isn't immediately in the run of things, but you will see when you get to, I'm not going to invite you to read it now, but just to put a mental line beside paras 50 to 55, because in 50 to 55, the Court of Appeal conducted a meticulous analysis of the dishonesty evidence that was at the foundation of the prosecution's case. And they did so because a submission was made that there was that evidence was questionable or didn't provide sufficient support for the inference of involvement in the murder. And at the end of this appeal, as you see from paragraph 62 on page MS 158, they continued, that's the Court of Appeal continued, Mr. Justice Ousley's publicity order, effectively. So they concluded that it was appropriate, despite the formal end at this point of the domestic criminal proceedings, they concluded that it was appropriate for the protection provided by the in-camera order to continue post-trial and appeal, for obvious reasons, because it was designed to protect the public interest in national security and or a witness identity. And so That is the position in relation to the criminal proceedings domestically. That was the end of it so far as appeals were concerned. So you are dealing here with a man who has been convicted of murder, who is and has been found by the Court of Appeal to be of thoroughly dishonest character, and who has advanced what the Court of Appeal concluded was a thoroughly dishonest defence. It is into his hands that my learned friend Lord Panic invites you to place national security and the protection of witnesses. So that's the second point by way of context. The third is that at all times it has been open to him to rely upon Article 6 in the domestic proceedings if he thought that Article 6's references to fairness assisted him in any way. And as we've seen in relation to the original in-camera order, he concluded that it didn't. But it's at all times been open to him to rely on Article 6. And he has now, in fact, made an application to the European Court of Human Rights. And it is, so far as the in-camera point is concerned, on precisely the same basis as the allegations of unfairness that he ran unsuccessfuley before the Court of Appeal Criminal Division. Can I make that good with two references? Firstly, you will see the summary in Mr. Justice Ousley's judgment with which we're directly concerned. That begins on MS 102, and the relevant paragraph summarising the nature of the complaint being made by this individual in Strasbourg is in paragraphs 16 and 17 on MS 105. Right? So MS 105, paras 16 and 17, summarising the grounds for the Article 6 application in Strasbourg and noting the coincidence. And if you could just, if you would, take up Appendix Part 2. I'm afraid I don't have MS numbers, but if we could go on the middle numbers. At page 98, we have the relevant part of his allegations of violation in his original application. So we're in the applicant's submissions to Strasbourg, and you see on page 98, you see the two-thirds of the way down by the second whole point, A, the in-camera hearing of the applicant's defence, bottom of page 98. You'll see the basic contention in the final sentence of paragraph 34, citation from various authority, pretty uncontroversial, the citation of authority, and indeed the propositions of principle, perhaps. But then the guts of it is really between 40 and 44. Could I invite you just to cast an eye down 40 to 44? Punchline you won't be surprised to hear is that these are effectively exactly the same grounds as were being run before the Court of Appeal Criminal Division.
Right.
And it's perhaps that places in context Mr. Justice Ousley's, it might be thought, rather tart remark in his judgment, which you may have noticed, to the effect that the only thing that Strasbourg had been deprived of is the ability to see how utterly misconceived the unfairness challenge might be on the back of the reasoning of the Court of Appeal Criminal Division, because exactly the same points are being run. But you see that's what's being said on behalf of the applicant. The government's observations are in the same bundle, same page numbering in the middle, if I may, 116.
Yep.
And you'll see there's a little section there which responds to this part of the this part of the claim. And again, I hope I don't do the learned author.
This is 24 to 28.
It's 24 to 28, exactly so.
Yep. Okay.
That's the relevant section, but I hope I don't do them a disservice by saying that's pretty much C Court of Appeal. No unfairness resulted. So that's the third point by way of context. The fourth is that the European Court has not made, I'll come back to Articles 34 and 38 when dealing with the submissions of principle, but the European Court has not in fact made any decision that the United Kingdom is in breach of any article of the Convention, procedural or otherwise. It has not purported to require the British government to produce any material to it. It has not made any request in relation to the in-camera material that it be produced or opened up to someone else, or that we take any step in relation to it. And my learned friend is, of course, perfectly entitled to point out the fact that Strasbourg has communicated the application, but this court will be well aware that there is all the difference in the world between the communication of an application and a decision on admissibility. And the government have submitted at the end of its observations, I haven't taken you to the relevant bit, but they've submitted at the end of its observations that for the reasons given in those paragraphs that I have just taken you to, the application to Strasbourg is indeed manifestly ill-founded. So that's the context in terms of the backdrop of criminal process and challenge to Strasbourg as a matter of fact. There are then, and perhaps this comes closer to the heart of it, three particular findings of fact by the lower courts of direct relevance to this appeal. That's the lower courts from whom this appeal derives. The first is the circumstances that persuaded the learned judge at the criminal trial of the sensitivities of the material covered by the in-camera order, quote, continue unchanged. That's a quote from Mr. Justice Ousley's judgment in these proceedings at paragraph 50, MS 112. It might be thought that the weight of the public interest at the time of trial is perhaps indicated by the fact that it was sufficient to persuade an experienced High Court judge to make the in-camera order he did in a murder trial, and then for the Court of Appeal to continue it at the end of the appeal. But the point here is that when it came 5 or 6 years later, 5 years later I think, when it came to this application in 2013, the learned judge reviewed those sensitivities to see whether time had degraded them and concluded in no uncertain terms that it had not. My learned friend read you paragraph 50, and it is indeed, we respectfully submit, a critical paragraph for the purpose of this appeal, because it sets the factual parameters against which these issues of principle fall to be delimited. My learned friend Lord Panic said that it's all deeply unsatisfactory that the PII process that led to those conclusions in paragraph 50 was accompanied by a closed schedule. That, we respectfully submit, is not in the least bit unusual. PII certificates are almost always, because otherwise you preempt the outcome, they are almost always accompanied by confidential or closed schedules, and the procedural aim is to open up as much as can properly be opened up into the open part of the certificate. That's the document you have at the very end of the appendix. And so that was the process that was followed. That level of detail was put into open, including the clearest possible indication in paragraph 11, to which attention has already been drawn, MS 162, that full details of the concerns are given in the schedule to the certificate. So no question as to what procedurally was being done, no objection at the time at all by the appellant. And for good measure, if my learned friend is saying this is all jolly unfair because no special advocate was appointed, special advocates are not a precondition to fairness in every PII application. Sometimes in the more complex ones, the court decides that it would be appropriate to invite the attorney to appoint a special advocate because of the complexity. But the court didn't feel the need to do so here. But in any event, all of that, I didn't want to leave the allegation of this was a thoroughly unfair process untouched, but all of that rather falls away because, as my learned friend entirely properly and candidly accepted, he can't challenge the findings in paragraph 50 anyway, for reasons which he gave. So that's the first of the findings. The sensitivities continue unchanged. Secondly, the learned judge was also satisfied that the purpose of the order would be undermined or put at risk by the disclosure of the material to the Strasbourg court. And that was so expressly, he found, whether or not Strasbourg sought to use the powers that it has under its rules. See, for this purpose, Mr. Justice Ouseley, again paragraph 50 from MS 112, but also in that respect, sorry, I've got a wrong reference, perhaps 50 will do for that purpose. 50 does it for that purpose.
Yep.
And the result of 1 and 2 together was that the learned judge found that there were, as he put it, very good reasons based on the public interest, evidenced in the public interest immunity certificate, for continuing the order to cover transmission to the European Court. And the third point is that balancing the various interests that were in play led the learned judge to the conclusion that he had no doubt that if there was a balance to be struck, it was a balance that should be struck in favour of non-disclosure to the European Court, even if they used their powers. And it is worth just flagging for you, perhaps not reading it now, but an invitation to read it at some point, the guts of that part of the learned judge's reasoning, which is between paras 58 and 66. 58 in particular for this purpose.
Right.
Can I just invite you now to cast an eye down 58 and then leave the others more likely sidelined? But you will see the nature of the interests that are being balanced. He's balancing, on the one hand, the sensitivities, national security, protection of witnesses, and indeed the protection through them of a criminal trial that might not otherwise have happened for murder, on the one hand, and on the other hand, the degree to which it might be thought on any realistic and sensible basis there would in fact be any form of real impediment in the exercise of an effective right of individual petition to Strasbourg.
The alternative to a criminal trial for murder would have been to set his case that he was just a secondary thief, or whatever the offence would have been. Yeah.
Pretty much. But certainly the prosecution being put to their election effectively on the murder charge.
Involved in fraudulent use. Yes.
Exactly so. I mean, there was obviously a link between the two, but and you will see that the learned judge expressed some fairly trenchant views in relation to the true nature of the impediment that Strasbourg would be labouring under. Look at paragraph 61 in particular. But the core point is that there is no challenge to any of those findings of fact now. The challenge is based on whether or not there is a power to make an order of this kind. In my learned friend's case is no power whatever the circumstances. It may or may not be that at some future point the divisional court will be invited to revisit whether the balance is struck in that way. I know Lord Clark was interested in that question. They left the matter open because no attempt was made to raise those matters at the divisional court level. And I just show you how it was left in the divisional court. It's paragraph 60 of their judgment, or 59 and 60, on MS 98.
Yes, I see.
But you'll note they weren't even asked, the divisional court weren't even asked to engage in that exercise, or to look at any confidential material, or to strike any balances, or do anything of that kind. And they did express, in fairness to them, in case anyone thinks there's a clear road where my learned friend would seek to raise it later, they did raise the question that they've posed in paragraph 60. But in any event, for the purpose of this appeal, not merely is there no challenge to those findings, but now despite a belated attempt to seek to raise proportionality as an issue in this appeal, as I friend recognised correctly, would face insuperable difficulties, not raised below and couldn't do it on a half-cock basis. But that proportionality challenge has now been abandoned, and that means, and it follows in any event from the 3 points that aren't disputed that I've just set out, that means that the premise for the assertion by Lord Panic of the absence even of power has to be that there is no power despite both the existence of a pressing need for that sort of order and despite it being proportionate in fact to make it. Can I turn then to the issue of principle that is raised? And I make 3 short points initially, if I may. Firstly, this is an argument about power, the powers of the court. No one is seeking to assert an executive diktat to withhold relevant information from a court. Secondly, it is an argument of the greatest importance given the consequences if the appellant is correct. He says that a court cannot even conduct a balancing of the relevant interests in play. It doesn't have power even to consider those matters. And the consequence of that will not have escaped you. The consequence is that the decision as to whether or not to create those risks, let there be no mistake about it, if risks exist of the kind found by Mr. Justice Ouseley, they are created or they come to fruition at the moment the material is provided. But the consequence is that the decision as to whether or not to take those risks, whether or not to put national security at risk, whether or not even to put the life or safety of a witness at risk, is in the hands of the individual applicant, here the dishonest murderer. It is for him to decide whether or not to create those risks of damage to the public interest. And he can do so in my learned friend's case, even if the damage would be of the most serious kind, putting lives at risk, putting national security at risk, and even if he is quite able to make the complaints he wishes to the European Court of Human Rights. Even let it be assumed that he can make out just about a case of relevance. He says no balance to be struck. So even if it's of the lightest possible or conceivable relevance, he says that's simply irrelevant. All of that is irrelevant because there is no power even to consider those balances. And the third point that leads to is that demonstrates that not merely is the argument important and deeply concerning in its consequences, but it is an extreme argument, as arguments about power often are. It's extreme because he asserts a right, in effect, to make those decisions, and it's extreme because he also asserts, and I'll come back to this in a short moment, that the right at the international level is a right to place any material before the Strasbourg court. And he says that right is breached if any impediment of whatever kind is placed on that by the courts or anyone else. Turn then to the stages of my learned friend's argument. You will have seen in the case that a lot of time and effort is devoted to the proposition that, in effect, access to the European Court is properly to be characterised as a fundamental right. That isn't, it appears, now at the forefront of the argument that was advanced at least orally, but if and to the extent that it continues to be relied upon, with respect, we disagree. Of course, access to the domestic courts has been so characterised, that's right. But the common law does not recognise and has never recognised a right of access, still less a fundamental right of access, to an international court. The provision of that sort of access to an international court or tribunal, and it doesn't necessarily have to be Strasbourg, one can think of any number of international courts or tribunals to which my own friend's principle might apply if it's good, but the provision of such access is a matter of treaty. It is therefore a matter of governmental choice, unless and to the extent that Parliament has intervened and has legislated to make the right a domestic right. But fundamentally, if it hasn't done that, it is a treaty-based right. There isn't a domestic legal right at all. That is precisely why, it might be thought, the Human Rights Act was enacted. And that is the guts of the reasoning in the Queen and Lions and all that line of cases. Lord Hoffman pointing out that the rights continue to exist on the international plane, and even though the schedule said Article 2, Article 3, Article 4, Article 5, Article 6, all that was doing was to create a replica of the rights, a facsimile of the rights, rather than strictu sensu incorporating them. But the point can be just as well illustrated, God forbid that it should ever happen, but just as well illustrated by the fact that Her Majesty's government could decide to withdraw entirely from the Council of Europe. Now, what the consequences of that might be would no doubt keep us exercised for quite some time thereafter were that to happen. But as a matter of constitutional principle, they could do so. And it's perhaps finally illustrated by the fact, again, as you remember from the argument that we had in the KU case, there was a difference in terms of timing. We signed up to the convention, I think it was in 1954, but the right of individual petition, remember all that line of cases that where there was a bifurcation or a difference between the two, we only gave a right of individual petition on the international level, I think in 1966. So until then, there wasn't even a right of individual petition, even though the international legal obligations existed. But all that serves to demonstrate that the common law does not recognise or serve to seek to protect on the same basis access to those sort of international tribunals as compared to access to the domestic courts, which of course would be protected by the Article 6 HRA right anyway, to the extent that impediments were placed in front of access to the domestic courts. The true position, therefore, is that both the right of individual petition and the rights that effectively comprise the right of individual petition, contained in Articles 34 and the flip side, Article 38, both of those rights are dealt with, or both of those matters more accurately, are dealt with on the international plane, and they confer no domestic legal rights. And of course, one of the consequences of that is that the domestic courts can't rule on matters to do with Articles 34 and 38. They can't. No one can come to you and say, frightfully sorry, government have behaved appallingly, could you do something under Articles 34 or 38? The answer would be you have no jurisdiction to make that sort of ruling. So that's the first initial point, which, as I understand it, has now at least been downgraded in terms of logical importance in my learned friend's argument. His argument, in truth, now proceeds by two stages. He says, first, that the nature of the right or the obligation under international law, under Article 34 in particular, is to create a prohibition on any impediment at all in the way of making an application to Strasbourg. And he says, for good measure, that it's clear, he has to say this, it's clear that the order places the United Kingdom in breach of its international obligations. The latter part I put in because it's no good just turning up and saying, well, we're in the sphere of international obligations. If you're going to make the principle of legality sound at all, you have to demonstrate that otherwise there would be a breach of those international obligations. And it is necessary, in response to that first stage of the argument, to be clear about what that actually involves by way of assertion in this context. As I say, I've already said, we are not dealing here with an asserted power to place impediments in front of applicants being exercised by the executive without constraint. The argument is about whether or not the court has power to balance interests and indeed rights, which the court has traditionally held dear. My learned friend says not. And as I've also already pointed out, it involves the proposition that the applicant must be, if I can put it this way, absolutely free to decide what material to adduce in those proceedings. It must be for the applicant alone to determine what material can be adduced, says my learned friend. And the first point to note, once that is understood, is that the domestic fundamental right of access to court, so just focus purely on the domestic for a moment, the domestic fundamental right of access does not go that far. No doubt there are cases where a prospective claimant can properly claim to have been positively and completely excluded from the courts. Right or wrong, the Witham case, all those years ago, was one such example. The imposition of very, very high or prohibitively high levels of access to court fees is an example. But, as the Divisional Court pointed out correctly, we submit at paragraph 22 of their judgment, none of the cases that are referred to in my learned friend's case and that were referred to by Ms. Brimelow before the Divisional Court, none of those cases involve a context in which other fundamental rights or responsibilities are in play, such as the right to life, such as the protection of national security. So he must assert a right that is even greater than would be accorded in relation to access to the domestic courts.
There is a distinction to be drawn, isn't there, between the right of a person to have their legal rights and obligations determined by a judicial body, be it a court or a tribunal, and the rules applicable in that tribunal about the material available in the determination of those rights. And the second has to do with the principle of a fair trial, which is a different concept, although allied, isn't it, from the concept of a right to have your rights and obligations determined by a tribunal.
My Lord, I entirely agree. That was the next bullet. I entirely agree. That is a clear and principled distinction. And the way that one can perhaps test it is by reference to what happens on an ordinary, and I say ordinary because pre-Justice and Security Act and closed material procedures and all of that, but an ordinary PII application. That represents a domestic control over the nature of the material or the evidence that can be produced, for good or ill for either party's case, to the domestic court. And the consequence, as you know from Al-Rawi and all that line of cases, but the consequence of a PII application being successful is that potentially relevant evidence is excluded from the court's substantive determination of the issues before it on grounds of public interest. So, my Lord, I entirely agree that that distinction is a proper and coherent one. But the irony I point to under this first point is that my learned friend's assertion that the Article 34 right is a no impediment whatever right, including in relation to the material that he can deploy before the Strasbourg court, is, ironically, a greater species of right at the international level than even exists by way of implication into the concept of access to court domestically, which is recognised to be a fundamental constitutional right. So that's the first point. The second point is that the Strasbourg jurisprudence and articles do not, we respectfully submit, go anywhere near a principle of the extremity which my learned friend espouses. They do not establish that any impediment, in the sense that he has used it, and in which it would need to be used to assist him here, that any impediment would lead to a breach of Article 34. Can I just remind you, if you go back to the convention, which is behind tab 5 in bundle 1 of your authorities, starts at MS 377, but bundle 1 tab 5, you were taken this morning to Articles 34 and I think also 38, but it may just be worth going back to them. And the key feature that we respectfully invite you to note is that the critical adjective in both Articles 38 and 34, final sentence, is effective. That word is replicated in both of the articles, and it makes the judgments that those articles call for, if anyone is going to assert a breach, relative, not absolute. And the case law of the Strasbourg Court, we respectfully submit, assists on that proposition. The reason that my learned friend did not, as my learned friend Miss Brimelow did below, seek to place reliance upon Article 38 in this court is no doubt because the Strasbourg cases on Article 38, which we respectfully submit is pretty much the flip side, or certainly an adjunct to and a support of 34 anyway, but the case law that is of interest under Article 38 demonstrates that Strasbourg is alive to the concerns about national security, is perfectly prepared to contemplate the domestic courts striking the various balances that arise in this sort of context, and considering in particular whether there is a need for in national security terms for material to be protected, and indeed goes as far as to recognise that they are not well placed to make those judgments. And so the moment you get into the Article 38 case law, my learned friend's argument for A34 being an absolute principle runs into the sand, because Strasbourg is not merely contemplating balance, it is contemplating balance by the domestic courts precisely because they are not well placed to make those sorts of judgments. And what ultimately then happens on the case law is an assessment by the Strasbourg court as to whether or not the domestic courts have properly, or the domestic authorities, have properly considered the matter. So in the Janovich case, they hadn't. There was no indication whatever that the domestic courts, the Russian courts in that case, had even thought about national security. By contrast here, as Mr. Justice Ousley pointed out in his own judgment, the United Kingdom, when this debate happens in Strasbourg, if it ever does, will be able to say, well, our domestic courts looked at this with conspicuous care. They looked in, they weighed, they considered national security, they updated it, they had a PII certificate, all of that plays in. The authorities I had in mind are those particularly referred to in the divisional court's judgment at paragraphs 29 to 32, MS 89 to 90. Do you see there's a summary in 29 of the relevant legal principles in the quotation in the Janovich case, and a summary of other principles or similar principles in the Nashirian Poland case at para 32. You'll see that gives a pretty decent flavour of the approach, and we respectfully submit, and there's been no challenge to this, perhaps this is all I need, that we respectfully submit positively that paragraph 28 of the divisional court's judgment correctly encapsulates the principles and approach that the Strasbourg court would apply. That does it in a paragraph, and we respectfully submit that that is a correct analysis of the Strasbourg case law.
That's an account of your submissions, Mr. Reid.
Yes, but I think they...
No doubt the court agrees with you, but...
Well, I think it does. I'm just wondering whether I've got any more than a pure inference that that's what they were doing. I apologise, lady. I think it is tolerably clear that...
Well, it probably follows that they did.
Read with 31, perhaps.
Yes, thank you.
Would that do it? Could you, you might also, while you're there, just put a line through. I don't know whether your version is the same, but we seem to have, no doubt because it's a thoroughly good paragraph, we seem to have the same paragraph 3 times from Al-Nashiri in Poland.
Yeah.
So at the bottom of MS 90, you can delete that paragraph and the one that follows over the top of page 91. So my learned friend says, well, no, it's not really to do about Article. It's not really to do with Article 38. It's all to do with Article 34. Well, that doesn't help him because the same adjective is used. It's about effective rights of access. Then he says, well, no, but that's, you don't worry about that. You now have to look at Sisajeva. And Sisajeva is really the last word on Article 34. And that, he says, demonstrates that the right in the final sentence of Article 34 is an absolute one. Again, with the greatest respect to him, we disagree. That is in Bundle 6, Authorities Bundle 6, tab 37, starting on MS 2055. And again, I don't need to take up much time with it, because I think you looked at all the relevant bits this morning, but you will see that the context in this case is fundamentally different. This involves, if I can summarise it in a sentence, hauling innocent people into a police station and interrogating them about various matters, including inter alia their application to Strasbourg, and the suggestion was that the police were effectively improperly putting the frighteners on them, so far as the application to Strasbourg was concerned. But the principles, as I think the Court has already noted in argument or in the observations made when my learned friend was making his submissions, the principles in 115 and 116 at the bottom of MS 2092 are simply not supportive of the absolute position or principle that my learned friend advocated. You see that the first statement of principle, fourth or fifth line in 115, to communicate freely with the court without being subjected to any form of pressure from the authorities to withdraw or modify their complaints. And then in 116, could we invite you just to circle in the third line the word improper, and 3 lines lower down from that in 116, unacceptable practices. But you get the flavour of it just from those passages. That is not, we respectfully submit, support for the proposition that the last sentence, improbably given the adjective used, of Article 34 confers an absolute right to communicate freely whatever the nature of the damage to the public interest in that.
Yep.
So what is the position as of today and in the future in relation to Article 34, assuming it isn't absolute? Firstly, there is and can be, we respectfully submit, no question of any breach at present. And that is because the applicant has been able to present his claim to the European Court, and the Divisional Court at paragraph 25 were right so to conclude, as had Mr. Justice Ouseley. He has been able to complain about the in-camera process, even though the arguments are exactly the same as those rejected as unarguable by domestic courts, and of course Strasbourg is not a court of quatrième instance. But to come to a question that my Lord Sumption asked my learned friend, the analogy with the Court of Appeal is not, that we respectfully submit, terribly helpful in this context, particularly given all that case law positively asserting they're not sitting as courts of appeal from domestic courts, domestic criminal courts. He can and has been able to complain to the European Court that he is being prevented from presenting his complaint effectively, as again the Divisional Court correctly noted at paragraph 27. And yet, despite all of that, there has been no indication from Strasbourg that they are planning on requesting or have requested or required the United Kingdom to do anything in relation to the sensitive material at this stage. They simply adjourned the matter pending this Court's consideration of this. There is therefore no current requirement, and it follows no current failure. The question then arises, I suppose, well, what about the future? And my submission there, again, is that the courts below were correct to conclude that it is, at the very lowest, far from clear that there would in the future be any finding of breach. We respectfully submit that the Divisional Court were correct in their treatment of the case law and the principles. I've taken you to that a minute ago. And we will make the strong submission in Strasbourg that there should not be a requirement imposed on the United Kingdom to start producing information of this kind. And that submission, and no breach of Article 34 or 38, and that submission will be positively supported by the exercise and the conspicuous care exercise by the courts in considering these issues, particularly the detailed judgment of Mr. Justice Ouseley and his factual conclusions on where the balance is properly to be struck, including specific findings about damage to national security and the protection of witnesses and so on. And of course it will remain open to my learned friend throughout to raise the issues of principle that they want to raise about the alleged unfairness of the in-camera process. But they will have to do that against the backdrop of the open findings of fact that led to that conclusion by Mr. Justice Ouseley in the trial. So we respectfully submit at the very least a strong argument of no breach even in the future. But it is to be noted specifically that even if the Strasbourg court were to find a breach of Article 34 or 38, the consequence would not be the production of material of sensitivity into an unsafe environment, placing the public protection at risk. And that, of course, is the consequence or bite of my learned friend's assertion.
Would it be open for them to reconsider or consider for themselves the safeness of what you call the environment?
Well, they could no doubt form a view on that. They could. But I'm not sure where. Well, in the end, that still wouldn't lead to the production of this sensitive material. The most it would lead to would be a finding that they'd made that judgment and they didn't agree, and they thought they were perfectly capable of providing sufficient protection, and as a result, the United Kingdom was in breach of Article 34. And then, at most, what happened in, I think, the Janovich case, which is the drawing of adverse inferences, which might or might not affect the substance of the convention complaint. But the point is that none of that would lead to the production of material, and yet the right that my learned friend has to assert would take all of that out of the hands of the court and place it in his hands with the damage potentially being created.
Yeah.
But more generally, and finally on this point, before I move to the second stage of the argument my learned friend advances, the Strasbourg court, like the domestic court, does not in any event, I think there was a brief reference to this principle under Article 6. The Strasbourg court itself recognises, to come back to Lord Toulson's point, that the right to adduce evidence is not in any event an absolute right, even under Article 6 case law, and even in the most serious context of criminal proceedings. One only has to think of, and we've cited for the general proposition, I'm not going to invite you to go to it now, but the Kurt case we cited at footnote 1 to our case. That's in Authorities Bundle 6, tab 38, it's para 79, for the general proposition that it isn't absolute. But one bears in mind all of those cases where Strasbourg first thought about PII in criminal cases, Davis, Rowe and Jasper in the United Kingdom, that line of case law, is all on the proposition that even in criminal proceedings, the right to adduce material for a court, even in that most serious context, is not an absolute one. So that's the first limb of his argument, that we are, and you can clearly conclude that we are, in breach of our obligations, so as to tee up, in effect, the second point, the second stage of his argument, which is to focus on the consequence of that. He says, if I can make good that there is a breach by the order of our international obligations, the consequence of that is that the court has no power to make the order. And the fundamental answer to that submission is that that is not the effect of the principle of legality on which he seeks to rely. International legal obligations, it's trite, are not, at least currently, and despite some possible views to the contrary in recent case law, they are not domestically enforceable without more. The general rule continues to hold good. The system is dualist. And that means that even if the government were in breach of its international obligations, the government could decide on the international plane that the public interest rendered it appropriate that it should be in a state of breach. But in any event, most of the case law on reliance on international law in the domestic courts was developed particularly in the pre-Human Rights Act era, when there was a considerable push to get the ECHR into domestic law by whatever route possible, and that went through various iterations. Two of them, by way of case law, are perhaps particularly relevant, both the cases cited by the Divisional Court in their judgment. The first is the well-known Brind case, Brind was, of course, about executive discretion and not judicial discretion, so different principles might be in play. But the fundamental point that is made in Brind remains a transposable and good one, which is that you can't, once you've accepted the proposition that international law is not immediately and domestically enforceable, you can't do by the back door that which you're not allowed to do by the front. And so if the consequence of the argument is that whenever you're in breach of international law, you effectively have to exercise the discretional power in that way, that risks breaching that principle. That was effectively the basis on which Brind was decided in the context of executive discretion. My learned friend Lord Panic at the forefront of the argument the other way. But the Divisional Court also cited the Ransom case. I'm not going to invite you to turn it up now, but that was a case about judicial discretion, the exercise of judicial power, and it established that international obligations, let me put it neutrally, international obligations could be taken into account, both in shaping the common law and its development, and as a factor in the exercise of judicial discretion or power.
Which case is this?
Ransom. It's referred to in the Divisional Court judgment, but it's in Authorities 3, tab 16. Yeah. And of course, in slightly different ways, you've had, we don't dissent from any of the statements of principle that are collected together in my learned friend's helpful case. He's got a paragraph with Lord Bingham in A and Lord Bingham in the Lyons case and Lord Hoffman in those cases. We don't dissent from any of those. The point that we make, however, is that none of them, even taken at their height for my learned friend, at their topmost height for my learned friend, none of them establish the proposition. Because the furthest he can take that line of case law is to say, well, it demonstrates that when you're exercising a judicial discretion, there should be a presumption, that word, or perhaps a strong presumption, that the discretion will be exercised conformably with our international obligations. The difficulty, of course, is that it is inherent in the concept of a presumption that it can, in certain circumstances, be overridden. And so even if he is right to say that there is a strong presumption, and it's at least questionable whether that's in truth the position, for reasons I'll come to in a second, it doesn't get him home, because a presumption is very different from the absence of a power thereafter. And the absence of a power thereafter, which is what he has to assert, comes much closer to the vice that was identified by the Lords in Brind. The reason I was a bit hesitant about the precise formulation of it is because it might be thought that when one was exercising a judicial discretion or power, the correct position in principle should be that international obligations are properly to be taken into account and can be taken into account. And if you express the principle in that way, it allows for the possibility that the precise nature of the international obligation, or perhaps the precise way in which it applies on the particular facts, may be uncertain. So there may be quite a difference in terms of the exercise of judicial discretion or power if one is dealing with a clear case where the obligation itself is absolutely clearly defined. It is a customary rule of international law, for the sake of argument, so at the higher end of the lexicon, and it is clear on the facts that it would be breached. But as we all know, from even the little dallying within the sphere of international law that I have done, the moment you get into it and try and work out what the principle of international law actually is, it becomes a slightly looser thing than you first thought it was. And applying that to the facts is even more difficult. And it might be thought that the correct principle in relation to international law and judicial discretion is precisely that it should be taken into account to allow for those fluidities to have their proper play in the exercise of what is ultimately a domestic discretion. But the core and short point is that even if my learned friend is right about the expression of that principle, it doesn't get him home, because a presumption is different from a bar. Right. And here, finally, the position is that the court had the power to make the in-camera order, had the power to continue it after the end of those proceedings, as the Court of Appeal did, and thus had the power to police it to ensure that its purpose is not and was not undermined. And of course, the power to make the order initially is unchallenged. It was tested in the Court of Appeal at an interlocutory stage. It was then tested in its effect after or during the appeal against conviction, and the Court of Appeal decided to continue the order at the end of all of that. And so, in my respectful submission, Mr. Justice Ouseley was perfectly entitled to conclude, as he did in paragraph 58, that the wholly justified, as he put it, the wholly justified purpose of the exclusionary order would be put at risk in circumstances in which the Crown could not now take retake the decision to prosecute. And so my learned friend is in effect asserting that there is an inbuilt exception, that the order can exist for all purposes, save only for an application to the European Court of Human Rights. And we respectfully submit that that is not a tenable position. So for all of those reasons, my lords, my lady, we respectfully submit that Mr. Justice Ouseley was correct. Lots of his judgment is not challenged. We respectfully submit that the divisional court were correct in the judgment and conclusion that they reached. Ultimately, we have power under domestic law to make, or the courts have power under domestic law to make the order that was in fact made. Domestic law recognises and values the rights that this order is designed to protect. In particular, it recognises and values the right for witnesses to be protected. It recognises and protects national security, in essence, the protection of the public, and it strikes a balance where rights and interests are in tension. And when one goes to the Strasbourg case law, what we do not find is anything to suggest remotely that they adopt a fundamentally different approach. When we go to the relevant Strasbourg case law, we find them doing exactly the same thing, but with the added principle that they see Janovic and al-Nashiri and that line of cases under Article 38, that they will respect the considered judgments that are made by the domestic courts in this area. Those are my submissions, unless I can assist further.
Thank you very much, Mr. Reedy. Mr. Hall?
My Lords, my Lady, can I respond briefly in the order in which the points were made? My friend began by submitting that my argument amounts to this, as he put it somewhat colourfully, that the power to put lives at risk would be put in the hands of a dishonest murderer. My submission is that the power is in the hands of Parliament, not the judges, because there is an international obligation to which the United Kingdom has subscribed. It's entirely a matter for Parliament if it wishes to confer expressly or by necessary implication the relevant power on the judiciary. If it does, well, so be it. I can only argue this case on the basis of the position as it is at the moment. Indeed, I would accept that if this court were to accede to our argument, it would be perfectly proper for this court to stay revoking the order made by Mr. Justice Ouseley until Parliament has had an opportunity to consider the matter. The courts have addressed in various contexts whether that is appropriate. There are a number of cases, in particular in the Hong Kong Court of Final Appeal, where that is precisely what they have done, where defects have been identified. The court gives its judgment. It reserves making any order until the legislature has had an opportunity to consider it. So I don't accept for a moment that our argument amounts to some sort of cavalier damage to the national security of this country. Our argument at root is an argument about who bears the responsibility for making decisions in this context. Is it Parliament or is it the judiciary? And we say, for the reasons I indicated in opening, and to which I will briefly come back, it is Parliament. So that's the starting point. Secondly, can I just give the court another reference to where we had made clear that the information which we wish to communicate to Strasbourg is the appellant's information and not information that he has obtained during the criminal proceedings. It appears again in the claimant's skeleton argument before Mr. Justice Ouseley, which is Appendix Part 2. Your Lordships and your Ladyship have MS 219.
Thank you.
It's page 142 of the original. 142 or MS 219. At the top of that page, the court will see the relevant information being within the claimant's own knowledge, having been obtained lawfully by the claimant, not being subject to any formal or other confidentiality agreement entered into by the claimant. And the court will have heard my friend Mr. Eadie did not challenge what I said in opening about the nature of the information. That is, it is our information in the sense of being known to the claimant before these proceedings, these criminal proceedings began, and not information that he has acquired by reason of the criminal case. Then my friend Mr. Eadie referred to the confidential PII schedule, which I accepted in opening is not central to the issue before this court other than by way of background. But can I just say this? My friend said it was not surprising that there was a confidential PII schedule. Of course, a PII certificate is usually used to exclude information from consideration by the court. It's because of its sensitivity that information is not available to a court. The case proceeds in its absence. What is, I submit, surprising about the present case is that the judge positively decided to make an order prohibiting my client from communicating his own information to the European Court by reference to a closed schedule without the appointment of a special advocate. I entirely understand my friend's point. It would defeat the whole purpose of a closed schedule if the material were widely communicated. But that's why special advocates are appointed. And I do say, as a background part of this case, it cannot possibly be fair to have proceeded in this way. And even if no application was made, Mr. Justice Ouseley, I respectfully submit, was quite wrong to proceed in that manner. Then Mr. Eadie emphasises, and he took the court to the relevant passages, that the Article 6 complaint is the same in substance as points that were made in the domestic proceedings. Yes, but there's really nothing surprising about that. That is the complaint of unfairness. And the applicant, in my submission, is entitled to invite the Strasbourg court to consider for itself the complaints of unfairness, and he's entitled to say that the Strasbourg court needs to see the sensitive material, as did Mr. Justice Ouseley, and as did the Court of Appeal, in order to understand the force of the points that he wishes to make. Then my friend Mr. Eadie emphasised that the restriction on my client is not some executive fiat. It is a ruling made by an independent judge of the High Court, to which my response is that for the purposes of an application to Strasbourg, the United Kingdom consists of the judiciary as well as the executive and the legislature. And if I'm right as to the scope and application of Article 34, then it applies to all organs of the United Kingdom, and it cannot avail the Attorney General that the prohibition, the restriction, was imposed by a judge and not simply by the executive. Then Mr. Eadie emphasises, he says, there's no domestic law right to apply to Strasbourg. Correct. He says the United Kingdom could at any stage withdraw from Strasbourg, again, of course, and he points out there was no right of individual petition at all until 1966. All correct. None of it in dispute. Our point is that there is now an obligation which the United Kingdom has accepted and a consequent right under Article 34 on the international plane. And the two issues arise as to the scope of that obligation and its implications for domestic law. Then Mr. Eadie said that in domestic courts, and indeed in Strasbourg, evidence may lawfully be excluded. There's no absolute principle that all material will be considered to be admissible. But there is no bar in our submission, either domestically or in any other case before Strasbourg, on a party placing material before the court, for it, the court, to decide on its admissibility and its relevance. And I say what is so unique about this case is that there is, we agree, a court which has a jurisdiction on the international plane, but one party is seeking to prevent the other from placing material before the relevant court for its assessment. And I say that's quite unique. Then we come to
When you say it's quite unique, you say there's no previous example of that at all?
None that we can think of, no. Where one party is prevented from placing before the court of competent jurisdiction material of which it is in possession, which it wishes to place before that court, for that court, after hearing submissions on each side, for that court to decide on its relevance, on its admissibility and its relevance. I say that's quite unique, that one party should prevent the other, one party being the United Kingdom, should prevent the other, being the applicant, from placing its case before the court of competent jurisdiction, there being no dispute that the European Court has a jurisdiction in relation to my client's complaint. Then we come to Article 34, and my friend disputes our contention that Article 34 involves an absolute right to place one's material before the court, and my friend relies on the word effective in Article 34, and indeed in Article 38. The high contracting parties, this was Volume 1, Tab 5, the high contracting parties undertake not to hinder in any way the effective exercise of this right. I say that doesn't help my friend, because in principle it does hinder the effective exercise of a right to prevent my client from deploying before the court of competent jurisdiction his case, that he is told you cannot make your case in the terms that you wish to make it before that court so that it can decide on the merits. Then my friend relied, he didn't take the court to the authorities, and I don't criticise him, and I won't do either, but he referred to the Article 38 cases which are in the bundle. And the Article 38 cases do, I accept, recognise that it is a matter for the discretion of the Strasbourg Court whether it will require the contracting state to provide relevant information to the European Court. My response is that we are not here concerned with the Article 38 powers of the court. We're not concerned with a request by the Strasbourg Court to the government that the government should provide information which is in the possession of the government. That's the content of Article 38. The present case concerns the appellant's wish in support of his application to communicate to the Strasbourg court information which the appellant, the applicant, is in possession of, his information, which he wishes to adduce in support of his application.
But doesn't Article 38 postulate that sort of situation, because the government would only be resisting providing the information if it might be of assistance to the other side, at least in the sort of cases that have been before the court, and therefore presumably the other side wanted the information. Does it make all the difference whether they've actually requested it in order to put it in, or whether they've said, look, the government should produce it?
In my submission, yes. If one looks at it on the domestic plane, it is one thing for me as the applicant to a court to have the right to place before the court the information of which I am in possession and which I believe supports the application that I'm making, so the court can assess its admissibility and its merits. It's entirely another matter for me as the applicant to say to the court, will you, the court, please exercise a power to compel or to request the respondent to the application to disclose information. That is inherently a discretionary matter for the court, which it may or may not accede to by reference to any number of relevant factors. But I repeat, what we're concerned with here is a restriction on my power as the applicant to provide information to the court. And indeed, Mr. Justice Ousley referred to this because he recognised, it's paragraph 38 of his judgment. We could just go back to Appendix Part 1, page MS 110. It's page 33 of Appendix Part 1. It's paragraph 38. His Lordship has gone through in some helpful detail, and my friend referred to this, the Janowicz case, which starts at paragraph 31. And at paragraph 38, his Lordship says the decision does not deal with the position where it is an applicant who seeks to rely on the sensitive material to which he and his lawyers have had access. Well, precisely so. That is Article 34. It's not Article 38.
Sorry, which paragraph was that?
38, yes. Can I give your Lordship the reference again? It's MS page 110 of Appendix Part 1, and it is page 33 of the appendix itself.
Okay.
And it's preceded with a number of extracts from Janowicz.
Yes, yes.
And we respectfully agree with what the judge says. Then my friend took the court to Sisajeva, which I don't ask the court to go back to. It's volume 6, tab 37. My friend said the context is very different. Well, yes, of course, it is a very different context. The point I make is that the Grand Chamber, and it is the Grand Chamber, states at paragraphs 115 and 124 the relevant principles for the application of Article 34. And I do say that our case falls within those principles. Paragraph 115, we are required to modify our complaints. We can't present our complaint in the terms we want to. And paragraph 124, yes, we are hindered in any other way. We're severely hindered in what we can say to the European Court. And although there may be disputes about the scope and application of Article 34, I say whatever else may be improper, which is the word that my friend Mr. Eadie emphasised in the judgment of the European Court, it cannot be for the respondent state to restrict the contents of an application to Strasbourg without a breach of Article 34. So that's my case on the first main point. On the second main point, the relevance of the international law obligation, if I'm right, as to the scope and application of Article 34. My friend referred to Brind, which was a case about the exercise, of course, of discretionary powers by an administrative authority. The appellate committee said that the minister, in exercising a statutory discretion, does not have to comply with Strasbourg obligations. And my friend, Mr. Eadie, said at putting it at its highest from our point of view, where there is a judicial discretion, there is a presumption of compliance with an international obligation, and he says a presumption, of course, necessarily can be overborne by other factors. We have two answers. Answer number one is we do not accept that this case is concerned with a discretion. Our contention is that the court, Mr. Justice Ousley, simply has no power to make an order of this nature in breach of the international obligations of the United Kingdom. It is at best a common law matter. And secondly, we say that if there is a presumption, and there is at least a presumption of compliance with international treaty obligations, the question which arises is what can overrule the presumption? And our submission as a matter of constitutional principle, analogous to Sims, is that only legislation, express or by necessary implication, can override the international treaty obligation of the United Kingdom in a human rights context. Nothing less will do, and nothing less will do because of a vital constitutional principle that the law will support the international human rights obligations of the United Kingdom, especially in a human rights context. My Lords, my Lady, finally, we respectfully agree with Mr. Eadie about the importance of this appeal, which my friend emphasised. It's important not just for the government and for those who apply to Strasbourg. Your Lordships and your Ladyship may well think that governments in other parts of Europe will be waiting to see if the Supreme Court of the United Kingdom rules that state authorities can, for reasons of state security or analogous matters, impede communications between an applicant and Strasbourg. This case is of importance not just in the national legal sphere, though it is, but from the point of view of international human rights generally. That's what I wish to say by way of reply, subject to any other matters that the court would wish me to seek to deal with.
Thank you very much, Lord Pannick. Thank you.
Thank you.
Well, thank you very much both to you, Lord Pannick, and to you, Mr. Eadie, for your submissions made in this important case, very clearly and helpfully. Thank you also to all of those involved in preparing the written cases that we found very useful. We will consider our decision and let you know in due course.
Thank you.
Thank you all. The court is now adjourned.